solve these questions. Solve the first question. What is the answer?
Option B.
Online? What is the answer?
B, sir.
B. Right. Why? It can introduce only in the Lok Sabha. Introduce either of the house. Is it right or wrong?
Wrong.
It can introduce only in the Lok Sabha, right? So rest all the statements are right. Fine.
Sir, the options to 111 మొత్తం delete చేసి only B
Those are the techniques to do it. Second one. The Rajya Sabha enjoys a special position vis-a-vis Lok Sabha in which of the following? Removal of the Vice President can be initiated in the Rajya Sabha. Centre's power to make laws in the state list can be initiated from the Rajya Sabha only. Formation of All India Services. What is the answer? Online?
A, sir. B, sir.
A or B?
B, sir.
B. B, A. So one who said B is telling one is wrong. One is removal of the Vice President can be initiated in the Rajya Sabha only. That is right? Yesterday I told you. Removal of the Vice President can be initiated in the Rajya Sabha, and Rajya Sabha it has to be passed by 2/3 of the vote. In Lok Sabha it has to be passed by 50%. Right? That simple majority, here special majority. Yesterday we discussed this, right? So statement A is correct. Then who said 1 and 2 are correct? Formation of the All India Service is also with the Rajya Sabha, right? All the three are the special provisions. I already told you formation of the All India Service has to be taken place only in the Rajya Sabha. Then also agreed by the Lok Sabha. Those who have the confusion, those who haven't done it right, write down all the 3 points. These are the only special provisions for the Rajya Sabha. Okay. See, once we are done the topic, we have to be able to do all the questions of that topic. Otherwise, it is half done. Right? Done? Have you noted the 3 points? Fine. We'll go for the next question. Answer this. It's about kitchen cabinet. What is the answer?
A, sir.
Yeah. Everyone online, you're following, right? You're able to answer the question. The answer is A. It is a group consisting of most influential cabinet. What I told you about the kitchen cabinet? Kitchen cabinet is an unofficial cabinet wherein the close associates, it's normally up to 4 to 5 members of close to the Prime Minister will be called as kitchen cabinet, right? Because they will almost spoke everything in secret. They won't tell. They'll discuss the ideas, right? That is why it is called as a kitchen cabinet. Okay, solve this. Which of the following is true in a situation where the Prime Minister is a member of Rajya Sabha? Option A, he will not be able to vote in his favor in the event of no confidence motion. Option B, he will not be able to speak on the budget in the lower house. Option C, he can make statements only in the upper house. Option D, he has to become a member of the lower house within 6 months after being sworn in as a Prime Minister.
Yeah.
Online? A, right? Fine. You are getting the subject, right? Okay, very good. This one, he will not be able to speak in the budget in the lower house. He can speak, right? Because he's a prime minister. Any minister can speak in any of the house. This doesn't make any sense. He can make statements only in the Rajya Sabha. Fine. This one, which among the following is not included in the Council of Ministers? Right. Council of Ministers में we have the cabinet ministers, Ministry of the States and deputy ministers. Right? They are called Council of Ministers. Fine. This one is a good one. Anti-defection law, collective responsibility, finance bills, finance commission. What's it? What? B. Okay. Now you understand. If you don't know all of them also you can answer. Right? Now know this trick of answering the prelims questions. You don't need to know each and everything. Right? By eliminating. If you know anti-defection law, you can answer this question. Right? Everyone following, or if anyone is feeling difficulty in answering the questions? If you're feeling the difficulty, we can solve that problem also. If you're following if you're able to answer these questions without difficulty, that means you're following really well. Okay, this is the last one. Consider the following statements regarding the national emergency. It can be proclaimed on the grounds of internal disturbance. Fundamental rights under Article 19 get automatically suspended in case of emergency. Third point, it is only on the written advice of the Council of Ministers that the President of India can proclaim an emergency. Select the correct statements using the codes below. 2 only, 1 and 2 only, 2 and 3 only, 1, 2 and 3 only. What option?
B, sir. 1, 2 and 3.
1, 2 and D is not the answer. Internal disturbance has been removed and replaced with armed rebellion. I stressed it many times, right? Then why you are making the mistake? Answer is C. 2 and 3 only. This is how the questions are framed. Yeah, this is very easy. If you know the concepts, you can play. But if you don't know, if you have any confusion about the concepts, khatam. You are out of the race. Clear, right? That has been changed. Where it has been changed? Which amendment? Which amendment? 44th Constitutional Amendment. Which article may it got changed? 350? 352 mein. Fine. Chalo, we'll go to our main topic. So what were we discussing yesterday? We were discussing about parliamentary privileges. Before that, we have spoken the special powers of the Lok Sabha. We have spoken the special powers of the Rajya Sabha. We already discussed about different types of bills. Money bill, ordinary bill, constitutional amendment bill. Right? Okay. Can constitutional amendment bill can be placed or can be start in any of the house, or it should be start in Lok Sabha? For constitutional amendment, the prior permission of the president is mandatory, or without prior assent? Online. For Constitutional Amendment Act, prior consent of the president is mandatory or not? Simple question. I told you three bills needs prior consent of the president. I asked you to note it down. Did you note it down? Check your notes. If you note it down, you will know. Three bills. One is money bill, One is Finance Bill 1, Constitution Amendment Bill. For these three bills, President assent is mandatory before introducing the bill in the Constitution. Now I am not asking you to remember everything here, I am asking you to remember the exceptions. If you remember the exceptions, out of these three, if you remember these three, whatever is the rest, President no need. Right? Simple. Now why are you making your life difficult when it is very easy to? At the end of the day, we have to solve the questions. For that, whether you are remembering everything or we are smartly studying, this is kind of a smart study wherein you are remembering only the exceptions, but you are able to answer the questions. Right? Fine. So, ineffective. What is guillotine? Wait, I asked someone from online. Online, what is guillotine? I did explain the meaning of this. What it is? Online? So you don't want to answer, you don't know the answer. What it is?
In discussing bills can also be, means they look all the bills, whether discussed or
The discussed bills and undiscussed amendments, not bills, amendments. Amendments can be pushed through the guillotine. So that means that every amendment is deemed to be discussed and passed. Okay, why this is important is because nowadays Parliament is using this weapon very frequently. So where we are, what were we discussing? Parliamentary privileges, right? All this we prepared, right? For till that. Okay. Parliamentary privileges. First we understand the meaning of privileges. What is privileges? What do you mean by privilege? The word, don't link the subject. Okay, in general, what do you mean by privilege?
special treating.
Means
Treating specially
privilege means privilege only applies to a certain section of people first. If it is applied to everyone, we don't call it as a privilege. The first difference, right? Then what is privilege?
we have some more powers.
Some special powers than the rest from others, right? So then we call as privilege, right? That can be anything in general. But when it comes to the Constitution of India, the members of the Parliament and the minister have certain privileges. Okay, so why they need certain privileges? No, this is a valid question, right? Now we are saying that they have certain privileges, fine, very good. But why they need that privileges? Why we should be treating them separately?
Because they want to cover for the smooth function of Parliament, because they are representing us.
Now privilege, you telling that representation by the people directly, okay, Lok Sabha, okay, they are directly elected by the people so that we can give some privileges to them. Fine. Why the same privileges are applied for the Rajya Sabha also?
They are working for us also. We should let them function.
Though they are directly elected or indirectly elected, they are representing the people of India, one way or the other way. So as they are representing certain people for their rights, or then it is because if you don't give the privileges, they may not be doing their job correctly, right? For doing their job, they need certain privileges, certain powers, or certain exceptions. Fine? Okay. Chalo, we'll discuss this. Parliamentary privileges are the special rights, immunities, and exemptions. Special rights and special powers. Immunities means, what do you mean by immunity?
Protection from all violations. activation of arrest.
Immunity means the general law won't be applied to you. You are immune to that. Right? Immunity ఎక్కడ విన్నాం ఇంకా
For president,
like in general immunity means the general law won't be applied to you because you are a member. Like exemptions, okay, few exemptions are also there for the members. This we are talking about all the members, elected, nominated, Lok Sabha, Rajya Sabha, right? All the members. Fine. They are necessary in the order of the why? Because in order to secure the independence, effectiveness of their actions. Why they need privileges is in order to secure independence and effectiveness of their actions. Without these privileges, houses can neither maintain their authority, dignity and honor, nor protect their members from any obstruction in discharge of the parliamentary responsibilities. Because we are giving them certain responsibilities that we call as parliamentary responsibilities. They have to go to the parliament in every session, they have to speak there, they have to debate on the bills, okay, they have to discuss, they have to participate in the committees, okay, they have to come back again after the session, they have to be with the people, they have to take the grievances of the people, they have to note it down, then in the next session they have to go there and they have to address the session about the grievances and ask the government to solve their problems. So there is a responsibility for every member, whether he is from the Lok Sabha or whether he is from the Rajya Sabha. So to do their responsibilities, to do their duties, they need certain privileges. Okay? Fine. The Constitution has extended the parliamentary privileges to the persons who are entitled and speak and take part in the proceedings of the House. Right? This include Attorney General and Union Minister. Attorney General also can go and speak in the parliament, right? Lok Sabha, Rajya Sabha. Attorney General also have certain privileges. Though he is not a member of any of the house, he can go and speak in any of the house. First point. Second point, he also have the same privileges as a member of the parliament. Remember this point. Who is Attorney General? He is a main lawyer of a government of India. Right? So, clear, right? What is privilege? Why they need privilege? Who got the privilege and all. Now, though these privileges are not applied to the president, it is applied to the Attorney General, but these privileges are not applied to the President of India. Why? He is a part of parliament, right? Then he is a part of parliament. Then why these privileges are not applied to him?
Because he has already much privilege, sir.
But not these privileges, right?
Sir, he will not take part in the proceedings also.
He will not take part in the proceedings, but all the proceedings are done by him, right? On his name. What about Vice President? Do he have these privileges? Parliamentary privileges. I am not talking about their privileges. He got a Rashtrapati Bhavan, he got a big car. No. Privileges. Vice President is also not a member. Then do the Vice President have the parliamentary privileges? Now I am comparing President and Vice President. I am asking a simple question. Now we have discussed that we have introduced a new topic called parliamentary privileges. Right. Now my question is this. Whether President have the parliamentary privileges, whether the Vice President has a parliamentary privileges. Now Attorney General, who is not a member, has parliamentary privileges. Right. Now, first question, whether the President is a member of Parliament or not. The Vice President?
No.
Attorney General?
No.
No, right? All these three are not the members. Okay. Now, my second question. Does all these three are part of parliament or not?
Yes, sir.
The AG is not a part of parliament.
If he is not a part of parliament, by whose authority he is going into the parliament and speaking?
It's not mentioned in Article 70.
When I was talking about union legislature,
The union legislature is a part of
then what is parliament?
Parliament is president, the constitutional parliament.
Then if he is not a part of parliament, then why Attorney General can go and speak in the parliament? Yeah.
That I don't know. Check it is given to you.
He is not a part of parliament. If that is the case, when the impeachment process goes on, the judges also can go to the parliament and defend themselves. That doesn't mean that the judges are part of parliament, right? These are the special persons. When they are called upon, they'll go and they'll speak in the parliament. They are not going regularly. Those persons who go regularly as a members are only part of parliament. Right? Why vice president is a part of parliament? Because he is a chairman of the Rajya Sabha. Why president is a part of parliament? Because he signs. Until and unless he signs a bill, it can't become an act. Right? Now have this clarity. Right? And having a clarity means you should know the reasons why. If you know why it is like that, if you know the reasons, you can answer the questions. If you don't know the reasons, if you're just reading this, and you will forget it. If you know the reasons, you can't forget it. Right? Chalo. Now, next topic is collective privileges. Collective privileges is nothing but all privileges for all the members of the parliament. Now, this is important. Right to publish its reports, debates and proceedings, right to prohibit others from publishing the same. First, right to publish whatever they are speaking on the floor of the house, right? But 44th Constitutional Amendment Act has restored the freedom of press, and they said that press has a right, without taking the permission of the parliament, press has a right to print whatever is going on in the parliament. But that should be exactly what is going on in the parliament, no interpretations. First thing. Second thing, there will be secret meetings. So whatever going in the secret meetings cannot be published by the press. Okay, that won't come under the freedom of press. Right? Remember this point. Remember 44th Constitutional Amendment Act. Okay? 44th is very, very, very important. More important than 42nd Constitutional Amendment Act. Fine? Second, it can exclude strangers from the proceedings and can hold secret meetings, right? That is a special collective powers. It can regulate, it can make rules to regulate its own procedure, right? Parliament can make its own rules and regulations. Parliament is making rules for all of us. It can make rules and regulations for their own, how they have to run the house. Okay. Here, Lok Sabha cannot make rules for Rajya Sabha. Rajya Sabha cannot make rules for Lok Sabha. They have to make their own rules. Right? Remember that. Don't think that Lok Sabha has more power, they can change the rules of Rajya Sabha. No. Each house is equally important and have same powers. They can punish the members as well as outsider for the breach of its privileges and contempt. If someone disturbs the house, someone ill-treats the house, someone spoke negative about the house, okay, they can treat that as a contempt. Normally contempt is associated with judiciary, but here we are also seeing contempt. Okay, someone say a wrong word on the parliament or on the speaker or on the vice president, in their activities, in their doing job as a speaker, as a chairman of Rajya Sabha, or as a member of the parliament. If they say something wrong, okay, then that can be termed as a contempt and they can be punished. So this punishment, this power of the punishment by the parliament, that's why we have placed it in the judicial powers. So that means parliament also have a judicial powers. Now if someone asks you a question saying that is parliament a quasi judicial body, you have to tell yes, right? It is also performing the functions of judiciary, right? Fine. Next point, it has a right to receive immediate information. Now, this is also important. Right to receive immediate information of arrest, detention, conviction, imprisonment and release of a member. Okay, arrest, detention, conviction, imprisonment and release. Now you know the difference between all these terms, right? Yes or no?
Yes, sir.
Pakka.
Between arrest and detention,
Arrest, detention, renditlo arreste. Detention is kind of a preventive detention. Right? Preventive detention without committing any crime. Right? This detention can be, this arrest should be, if a person is arrested, he should be put in the police station or in a jail. This last year 2021, this is the question. They asked the difference between judicial custody and police custody. Right? Do you think any book has mentioned this? What is judicial custody? What is police custody? Right? That was the question. Now that's why you have to know the meanings of it, because nowadays the trend is he's asking. Now there is a possibility of asking bails. What is anticipatory bail? What is this bail? What is that bail? Different types of bails. Right? That is also not mentioned in any book. Right? Because that is in the newspapers. He's asking the questions from them. Okay. So, okay, tell me what is the difference between police custody and judicial custody? Someone is arrested, right? According to Article 20, they have certain powers, right? Right? What? Within 24 hours, he has to be produced before the magistrate. Magistrate has the power to tell the police or to arrange to give a judicial custody or police custody of that prisoner. Police don't have the authority. Only magistrate, a judge has the power. Right? Once within 24 hours a person is arrested, is presented before a magistrate and they will hand over the file. Then the magistrate will write, okay, judicial custody or police custody. Right? Now, this is the question asked in the last year prelims, 2021 May. What happens if he writes judicial custody? Means it he has to taken to the court. What happens if he writes police custody? Police custody means he has to be, police will be taking him to the police station and put it in the lockup in the police station. Judicially custody means that person will be taken to the jail, sub jail, and put it in the under the jailer. Right? That is the question asked. And what he did, he just flipped it. For police custody, he put the judicial custody. For judicial custody, he put the police custody, and he gave the two statements. That's it. Question. If you know this, question is right. If you don't know this, question is wrong. Fine. Detention. Detention. Now, the question here is this. A person is detained. A detention person should be produced before the magistrate within 24 hours? Yes or no? Online? No. No. Only arrested person, not detention person. Right? First thing. Remember that. Because he is detained, he is not arrested. So now, a detained person can be put in the jail, police station. Can we put it in his house arrest, or can they be put in any bangla of the anywhere, whichever the police thinks fit, right? When a person is detained, police has more power. When a person is arrested, judge has more power. That's why the politicians are detained, not arrested. రైట్. ఇప్పుడు రేవంత్ రెడ్డి బయటకు వస్తా అంటే డిటైన్ చేసి పడేస్తున్నారు ఇంట్లో. అప్పుడు హీ కెనాట్ డూ ఎనీథింగ్ బికాస్ పోలీస్ హ్యావ్ ద అథారిటీ, రైట్. అది డిఫరెన్స్. ఎందుకంటే ఈ మధ్య ఈ కేసెస్ చాలా వస్తున్నాయి కాబట్టి నో ద డిఫరెన్స్ వాట్ హ్యాపెన్స్, రైట్. ఫైన్. కన్విక్షన్ అంటే judgment for the crime he did, he got the punishment. Conviction is nothing but the punishment. Imprisonment ante undergoing in the jail the imprisonment, right. Release of the member, he is released from any of this. Fine. Clear kada? A words ki meaning ane chala important. Clear. Okay, next point. He can institute enquiries, order of attendance of witnesses and send the relevant papers and records. So Parliament has the power to do enquiry. Something has happened here. Suppose a theft has happened in the Parliament. So the chairman can establish an inquiry committee on what has happened, why it has happened, to recommend the suggestions for not to happen that in the. Okay. Yeah. Courts are prohibited in inquiry into the proceedings of the House or its committees. Now, whatever is happening in the Parliament, courts cannot interfere. Okay? Whatever they speak, whatever the decision of the speaker, means either in Lok Sabha or Raj Sabha, and in their committees also, whether they are, how they are running their committees, what they are discussing, their committee reports. Suppose the report is recommending something against fundamental rights. Per se, let's say for example, they formed a committee in the Parliament, and the Parliament, that committee has recommended something against fundamental rights or something against Supreme Court. Let's say for example, they cannot term that as a contempt of court. Normally, if a person speaks something against the Supreme Court, that can be considered as a contempt of court and he can be punished. But when a parliamentary committee or a person in the Parliament who is speaking, they say something against the Supreme Court also, they cannot act because they have this protection. Parliament have this protection. Remember that. Fine. Okay. No person, either a member or outsider, can be arrested, and no legal processes, either civil or criminal, can be served within the persons of the House without the permission of the presiding officers. This is important. No person, either the member or outsider, can be arrested. No legal processes can be served within the persons means within that Parliament, right. ఇప్పుడు పార్లమెంట్ జరుగుతుంది, మెంబర్స్ని వచ్చి నువ్వు అరెస్టెడ్ అని లోపలికి వచ్చి యు ఆర్ అరెస్టెడ్ అని తీసుకుపోవడానికి లేదు. సరే, మెంబర్స్కి అదే ఆ రైట్ ఉందా అంటే లేదు. లోపల ఒకవేళ దేర్ వాజ్ ఏ వాట్ వి కాల్ ప్రెస్ రిపోర్టర్ హూ ఈస్ సిట్టింగ్ ఇన్ ద స్టాండ్స్ ఆఫ్ ద పార్లమెంట్, without the permission of the speaker, no one can go and arrest that person, right, because that is sacred place, right. And speaker is the headmaster of it, and without headmaster you cannot go and enter into the and arrest someone, right. Clear, right. That is collective responsibilities, collective privileges. Now these are the individual privileges. Okay, individual privileges, the most and important individual privileges. Any member, though he is a nominated member, though he is an elected member, Rajya Sabha or Lok Sabha, cannot be arrested before 40 days or after 40 days of a session. That applies only to the civil cases, not to the criminal cases. Not to the criminal cases, fine. Clear ikkada varaku kada. Now a person can be arrested in civil cases, criminal cases, detention also. My question here is, this privileges of 40 days before and 40 days after will apply to civil cases, criminal cases, detention. where it applies. No.
Only civil cases.
Only civil cases, not to the detention, not to the criminal cases. Remember this.
Before 40 days.
There was a session, right? Session ki before 40 days, after 40 days, no person can be arrested. A member cannot be arrested. Fine. On what cases? Now, a person arrest cheyalante, there should be case, right? Civil case untadi, criminal cases untayi. Edi kaakapothe detention untadi. Right? Civil cases ki maatrame. Criminal cases ki he can be arrested at any time. Okay? Detention anytime.
Why that 40 days option, sir? Before and after?
Because they have to prepare, right? Why 40 days, I don't know. But there is 40 days.
I mean, why that certain period?
Earlier what happened, there were no flights. They had to go by train, right? And they have to go there. They will be going normally 1 week before to Delhi to adjust the environment and all. And they'll go there and they'll sit and they'll prepare for the session. Normally earlier people used to go to the parliamentary library and they used to read all the things. They'll do draft all the questions. Now their secretaries are doing all the job. They are just flying out. Tomorrow is a session. Now they are flying out. Earlier at the days when the constitution was formed, this was not the case, right? But that rule is still continuing, right? Okay, they have the freedom of speech in the parliament. Again, we discussed this. They have this freedom of speech in the parliament. That means they can speak anything that cannot be come under the lens of judiciary. Fine. No member is liable to any proceedings in any court for anything said or any vote given by him in the parliament or its committees. This freedom is subject to the provisions of the constitution and the rules and stand orders regulating the procedure of the parliament. They are exempted from the jury services. What is jury service? No, yeah. Means to give evidence and to appear as a witness in any case pending in a court when parliament is in session. If you are a witness in any case, when the case comes to the court, you have to go there and you have to tell to the judge, right? That is called jury service, right? What is? To give evidence or to be a witness when the parliament is in session. They are exempted. Otherwise, police will come and take you, right? But when parliament is in session, they are exempted from this jury service. Fine. Now, breach of privilege or contempt of house. When any individual or authority disregards or attacks any privileges or rights and immunities either of the member individually or house as collectively, then the offence is termed as breach of privileges and is punishable by the house, not by the court. Okay, when the breach of privilege aina, contempt of the house aina, who will punish? House will punish, whichever is the house, not just the speaker. Yeah, if that happens in the Rajya Sabha, chairman will also get punished, right? So house will punish, right? Okay, from where this power has come? Article 105 and Article 194. 105 is for Parliament, 194 is for state legislatures. Fine. Following okay, any act, omission which obstruct the house, its members or its officers in performance of their functions, or which has a tendency directly or indirectly to produce results against the dignity, authority, honor of the house is treated as contempt of the house. Now remember this point. Contempt of the house is arthamain kada. Now what we say, anything spoken against or anything done in the parliament, right, on a member, on the chairman, this we discussed. And if they come and did anything nonsense in the house, that can be said as a contempt. Suppose they came in the well of the house and they are danced. That is a contempt, right? That should not be done in the house. And if they attack any officers who is performing their duties in the house, like Lok Sabha mein Lok Sabha secretary untaru, Rajya Sabha mein Rajya Sabha secretary untaru, and there will be few officers sitting in the well. And if someone goes and attack that member, means attacking a person who is working in the, right? So then that also can be regarded as a contempt, right? Not just the members, the officers who are working in the houses also cannot be attacked or cannot be said anything, right? Remember this, officers kuda unnaru anedi. Fine kada? Okay, sources of privileges. Now, as we told that 105 from the constitution has given the privileges for the parliament. Does only 105 or any other sources are there? Right? So, normally parliament has not passed a privilege act. If they want, they could have passed, but till now they haven't passed a special act for their own privileges. So, all the privileges which they have right now came from Article 105. Okay, Article 105 and the constitutional provisions 105 and various laws made by the parliament, rules of both the houses, parliamentary conventions, judicial interpretations. These are the sources. Note down all the points. I am telling you to note down. Because if a question comes regarding the parliamentary privileges and if they ask what are the sources, katam. Then okay, next is sovereignty of the parliament. Now my question here is a parliament sovereign? What do you mean by sovereign? We discussed this concept in the preamble topic, right? What is sovereign? Yeah, supreme authority. What are the external forces that can be there that can hurt the sovereignty? There were two forces we talked about, external and internal. What is external? Any other country who is pressuring us to take any decision or forcing us to take any decision, that is external. What is internal? Any group or any organization or any committee which is forcing a country to do or what not to do, then it's called internal, right? If there is external or internal, then we can say a country is not a sovereign, right? Fine. Now, doctrine of sovereignty of parliament is associated with the British Parliament. Okay, sovereignty means supreme power within the state, that the supreme power of the Great Britain lies within the parliament and there is no legal restriction on its authority and jurisdiction. Now, in Britain, there is no legal restrictions. Whatever the parliament is told, that is 100%. That is taken for granted. But that is not the same for India. Indian parliament is not a sovereign body. Remember that. Whereas British parliament is a sovereign body. Indian parliament on the other hand cannot be regarded as a sovereign in similar sense as their legal restrictions on its authority and jurisdiction. Right? How can I say this? Now I told you that Indian parliament is not a sovereign body, yeah? Okay, fine. But why? Why? It can do whatever it wants. What are the restrictions? Why we cannot say our parliament or Indian parliament is not a sovereign body? So that means only after 1973, after Keshavananda Bharati case, this basic structure came, right? Before that, is it a sovereign body? Your answer is right, but not 100%. Half right. Anyone?
Sir, if the bill passed in Parliament is against Constitution, it can be suspended by court. In such sense, it's not a sovereign.
Okay, if at all any act passed by the constitution, if it is against the constitution, then it can be suspended. That bill can be suspended by the court. That is a valid reason. Okay, means our parliament is not absolute. Absolute means sovereign. That is one. Second, regarding the jurisdiction, parliament can only make the laws on central list and concurrent list, not on the state list. Fine. It's an exceptional cases here in general. Fine. Fine. Clear, right? You are able to think in a polity way, right? Think as a legal expert. Fine. Very good. Good answers. I am impressed.
Then how Parliament is sovereign, sir, is headed by Queen.
No. In UK, there is no basic structure. In UK, there is no state list. Whatever Parliament does, it is absolute. Right? UK, they don't have a constitution, written constitution. Yeah, they will go with the conventions. As that is only conventions that can be changed. There is no constitution. Written constitution is not there in the UK. They work with the conventions. Means established practice. Fine. That's why we can say that the UK Parliament is sovereign. That we are not saying that the Congress or the Senate of US is sovereign, right? Because if they go against the Constitution, the Supreme Court of the US can struck down that act. Right? Same as ours. That's why only UK is exception for this. Only UK Parliament is sovereign body. Clear? Clear? ఇంకేమైనా డౌట్ ఉందా దాంట్లో ఆ టాపిక్లో?
But they pass the bill if it's against the majority or minority, but it need not be checked by courts, sir.
So if they pass the bill in the Parliament, it is taken for granted. Whether it is against majority, whether it is not against minority, that doesn't matter. Right? If they have the majority support in the Parliament, only then the bill can be passed in the Parliament, right? If they don't have the majority support, a bill cannot be passed in the Parliament. It's as simple as that. Once it is passed, it is passed. If they want to change it, they have to go back and pass another legislation. Now, we'll come to that point next. What about what happens if in India they passed a bill and they don't want that bill now? What happens to the farm laws? There's 3 farm laws have been passed, right? 1 year back. And recently before the UP elections, they have taken that laws back. Correct? Newspaper mein hai, right? That is in the news. My question is, how can they take back the laws they made? They passed in the Lok Sabha, they passed in the Rajya Sabha, President also given the assent. That means it became a law. Now they told that we are taking the laws back. How can they do it?
The same way they pass the law, again,
Can they do it with the ordinance?
yes, an organization.
Can the president only can take a decision? No, because Council of Ministers has recommended not to. Then the president struck down it. No, there are many possibilities, right? I'm telling the possibilities. The first possibility is Council of Ministers said to the president that struck down it. First thing. Or Council of Ministers said the president did pass an ordinance. for its removal. I'm talking about the removal of these formulas. I'm just talking about these formulas. Suddenly, on a special day, Modi has come and there, we are taking back the laws. Taking back the laws. This is what he told, right? My question is, how can that be done? Correct? Question అర్థమైంది కదా. Now, possible ways of doing it. Possibilities చెప్తున్నా, కరెక్ట్ అని చెప్పట్లే. So that how the way you are thinking, I just want to know. First is kind of what I told. Council of Ministers said the Parliament says the President to remove it. Right? Council of Ministers has said the President to pass an ordinance. Or Council of Ministers has said the Council of Ministers has put a new bill for that removal. Or they have taken back the bill already existing and they passed it again. What should be done? As said by the Prime Minister, I'm taking all the 3 laws back. న్యూస్ పేపర్ నిజంగా చదువుంటే మీకు అక్కడ మెన్షన్ చేస్తారు వాడు హౌ ఇట్ ఈస్ డన్ అన్నది, కానీ చదువు. కరెక్టా? ఎంతమంది చదివారు న్యూస్ పేపర్? అసలు చదువుతున్నారా న్యూస్ పేపర్? Fine. That can be done. We'll discuss that also. But I'm telling you in general that can be done by passing a new act saying that whatever is there, the 3 by this bill is passed for the removal of this 3. They have to pass it in Lok Sabha, Rajya Sabha, President has to sign. Or if this house is not in session, they can go with an ordinance. These are the only 2 ways. Fine? That is a very easy answer, but I don't know why you're not answering it. Chalo, we'll go for some miscellaneous topics. First, Office of Profit. This has come multiple times whenever we are talking about the member of the Lok Sabha, member of MLA, MP, whatever, President, Vice President. For everyone, what is the qualification? He should not be a Office of Profit. Right? Now the question is, what is Office of Profit? Now we'll discuss this. This is important because this is always in the news. Right? Because now Vice President and Presidential elections are coming. This is again going to be important for this year. First, if an MLA or MP holds a government office or receives benefits from it, is termed as Office of Profit. Holds the government office, right, and receives any benefits from that office, then that is termed as Office of Profit. Clear? Second point, a person will be disqualified if he holds Office of Profit other than office declared not to disqualify the holder by law passed by the state legislature. Suppose President is going for the re-election. Okay, then the Parliament has said that when the President is going for the re-election, because President is a continuous process, he cannot be termed as an office of profit. For that reason, you cannot. So they have given certain exceptions. Right? President when he is re-electing, Vice President when he is re-electing. Right? Because President and Vice President election has to be done before the term ends. Right? So because you are again contesting, that doesn't mean that you have to come out of your office and contest. Right? But when a minister is competing for a presidentialship, he has to get out of the ministry. Fine. Clear? Okay. The Parliament Prevention of Disqualification Act of 1959 exempts several posts from the disqualification on the grounds of 1959 law. They have given certain exceptions. Okay, on Office of Profit. Certain positions lo unna vallu, certain offices hold chese vallu, because that offices has to be run. Example, President and Vice President. Clear? Ekkadi nunchi vachinda power? This Parliament Prevention of Disqualification Act 1959. It is not there in the original constitution. రైటా? ఒరిజినల్ కాన్స్టిట్యూషన్లో ఉందా లేదా అని ఇట్లా అడుగుతారు క్వశ్చన్స్, రిమెంబర్. ఓకే, వెన్ ఎవర్ దిస్ ఆఫీస్ ఆఫ్ ప్రాఫిట్ కా ఇష్యూ కమ్స్, who will decide it whether he is in the office of profit or not? Election Commission of India, Speaker of the Lok Sabha, Chairman of the Raj Sabha, President. President. President will decide the matter regarding the disqualification with the consultation of Election Commission of India and act accordingly. ఆఫీస్ ఆఫ్ ప్రాఫిట్లో ఉందా లేదా అనేది ఫైనల్ డిసైడ్ చేసేది ప్రెసిడెంట్ ఆఫ్ ఇండియా. అది ఎక్సెప్షనల్ పవర్ కాబట్టి రైట్ డౌన్, రిమెంబర్ ఇట్. రైట్? ఓకే. నాట్ బీన్ డిఫైన్డ్ ఇన్ ద కాన్స్టిట్యూషన్, నాట్ బీన్ డిఫైన్డ్ ఇన్ ద రిప్రజెంటేషన్ ఆఫ్ ద పీపుల్ యాక్ట్ 1951. Remember, this office of profit definition is not there in the constitution and representation of the people act 1951. It is for the courts to explain the significance and the meaning of this concept. Who defined the concept of office of profit? Courts, not parliament. Again, remember this important point. Fine. Supreme Court in this case is important. Paryadut Bardoli versus Swapan Roy in 2001 has laid down 4 broad principles on what is office of profit. Okay, office of profit means question వచ్చే ఛాన్స్ ఉంది 10 మార్కర్కి. సో 10 మార్కర్ వచ్చినప్పుడు you have to define what is office of profit, you have to establish what is the significance and write down this case and write down these 4 principles on which office of profit can be decided. Right? The first point is whether the government exercises the control over the appointment, removal or performance of the functions of that office. If that office is controlled by government on appointment, removal and performance of the functions. Appointment, removal and performance of the functions. If the government is involved in this 3, appointment, removal and functioning of that office, then that is declared as office of profit. Clear? Second one, whether the office has any remuneration attached to it. If that office has any remuneration attached to it. Now, here the government is controlling an office and it has an appointment, removal and all. But I can say that though government is appointed me, I am not getting any remuneration, I am doing the free services. I can tell, right? So, if at all any remuneration is attached to it is the second point to be noted. Third one, whether the body in which the office held the government powers, that is releasing money, allotting the land, granting the licenses, if this power is given to that body, then that body, if someone is working in that body, is termed as office of profit. Right? Fourth one, whether the office enables a holder to influence the way of patronage. Now, suppose he is not appointed but he is in there, but he is influencing the way of getting someone licenses, someone the contract, right, from the government. If we can influence by sitting in that position, that can be termed as office of profit. Remember these 4 points here. Normally you cannot get it in normal books, but if you can write these 4 points and explain the meaning in the definition, in the introduction, what is office of profit and who has the final authority in consultation with the Election Commission of India, President has a final authority on whether an office is office of profit or not. Right? Remember that point and these 4 points. Note it down. Done?
clear an officer's office of profit, these 4 points must be satisfied.
Hmm.
4.
Not all 4, anyone can be. Anyone or all 4 or any 2. One or any. All. Right? Not exactly ఒకటి వచ్చింది ఇంకోటి రాలేదు. That's why I told you, right? అపాయింట్మెంట్ రిమూవల్ కూడా గవర్నమెంట్ చేసింది, కానీ నాకేం రెన్యూమరేషన్ రావట్లేదు కాబట్టి డోంట్ కాల్ మీ ఆఫీస్ ఆఫ్ ప్రాఫిట్ అనడానికి లేదు. ఏం రెన్యూమరేషన్ రాకపోయినా సరే, ఇఫ్ హీస్ ఇన్ ద బాడీ, బట్ హీ హ్యాస్ అ పవర్ టు ఇన్ఫ్లుయెన్స్ ద గవర్నమెంట్ by getting a license, for getting any land. So that means he is in the position of influencing. So that is called office of profit. Office of profit is nothing but the person who is office of profit ekkada ochindi manaki, members of parliament, members of legislature, vice president elections, president elections. So when they are going to be a representative and going for a election, okay, if they are in the office of profit means they have an advantage over the other candidate. So whether he is at advantage, how we can say he is at the advantage? He should be in the government office. He is an appointed position. He has the power to influence the government, right? Whether he is getting the salary from the government, even though he is not getting the salary from the government, he can influence someone to get a license. So that he can, if he has this many powers, he can influence the elections. If he can influence the elections, the other person who doesn't have this power is at the discrimination, right? Both has to be at the equal stage when they are going for the elections. So to get that equality in contesting aspirants, this office of profit has become an important tool. Why this office of profit is provided or implementing in the elections means to provide a level playing field in the elections. Otherwise, the someone who has these powers can influence the election, right? That is the main reason, right?
For example, chairman of SBA is an office of profit.
Why chairman of SBI can be treated as office of profit? Because SBI is a central government bank, though it is not governed completely by the government, but major shareholder is government of India, right? So it can be termed as office of profit. Likewise, clear kada topic? Chalo. Now bringing or repealing a law, this is what we talked about, the formulas and all. Means nullifying a law. A law is passed, but we don't want that law anymore. What should be done? What should be done? A law is served in the parliament, thinks there is no longer a law exists. Now there is something called as sunset clause. Remember this. What is sunset clause? When a law is passed, they will mention in the sunset clause, there will be a clause called sunset clause. There they will mention this law will be for next 5 years. After, if that is there, this clause is there and they mention the term, after 5 years this law doesn't exist. That is called sunset clause, right? This is how we can repeal the law, means that law doesn't exist anymore. One is sunset clause. The other way is to pass another legislation to repeal the law. There is a law, now we want to discontinue the law. First one is, if it is in the sunset clause, how many years is there? Only that years it is a valid. After that it is no more. If we want to remove it right now, if there is no sunset clause, then again we have to pass another legislation for the removal of that act. Okay. Article 245 of the Constitution gives the Parliament to power to make laws and also power to remove the laws. Right? Also state legislature has the power to make the laws for the state. Parliament draws this power of the repeal from the same provision. Like power to make the laws and power to remove the laws came from the same provision. Article 245. Remember that. Okay. Now how we'll go in some detail. How it can be done? A law can be repealed either its entirety or a part, or even just to an extent of it is contravention to the. Now this is the law. You can remove the whole law, or if only some part you have some objections, you can remove only some part of the law also, right, per se. Now parliament has not passed this one. Now in general, let's take for example, parliament wants, now this is the whole law, right? First thing, what I told you, parliament wants, they can repeal it, they can pass a law, another law, and they can change, remove that. First thing, and only this part they want to remove, they can remove only this part also, any part. Fine. Now, without passing in the parliament, can a law may certain part or the whole part can be removed? No ordinance, no passing of the law in the act. But I want this law to be removed. Total. Now let's say this law name is ABC. This is a law. And I don't want this law to be there. Right? I am a lawyer. Fine. Normally if the parliament don't want, they can pass an ordinance or they can pass a legislation and remove the law. Is there any other way than this two? Ordinance or legislation? Can any law can be removed? Ordinance okati, legislation okati pakka. By this we can remove a law which is passed in the parliament and signed by the president. That is called law, right? Once it is passed by both the houses and signed by the president, then we call that as a law. My question is, a law, it's already there now in the statute books. It can be removed. I am already telling you two options. First is ordinance, second is legislations. Is there any other way? Think. I already explained this. There it is explained in one article. Tell me the article number. You are telling the same here. Ordinance and legislation I am not talking about. These two I already given you options. I am talking about there is another one. With that article, I can remove the whole law or I can remove the part of the law also. But it has to satisfy a condition. If that satisfies that condition, I have an option of removing the whole law or removing a part of the law. No. No one is thinking, or you're thinking? You need some time? I'm talking about an article in the Constitution. Your answer is correct. But tell me the article. Which article has given the Supreme Court that power? I discussed that topic, that's why I'm asking this question. Chalo, don't tell me the article number, at least tell me which part of the Constitution has this article. I can do this. Article 13, part 3. What I told you in Article 13?
Consistent.
If there is a constitution, any laws which are in contravention with fundamental rights can be removed. That applies to the post-constitution, pre-constitution. Pre-constitution laws ki separate ka Supreme Court cannot tell anything. Only the things which are according to the fundamental rights and according to the constitution can be passed. Let's say in the whole act, only this much part is according to the constitution, only this part will be passed, this part won't pass according to Article 13. That is pre-constitutional acts. Okay? Post-constitution act, now here Parliament has passed a bill. Some part is not according to the constitution. Supreme Court, by the power of Article 13, can say that, can remove this. Okay, per se, if total act is not according to the constitution, it can remove the whole part. That is the power of Article 13. That's why Article 12 and 13 are very important. These are there in the part 3 of the constitution before fundamental rights itself. Why they have to mention these two articles before fundamental rights? These are not two fundamental rights, right? In part 3, I told you that 12 and 13 are not fundamental rights. But why they have to keep that in the part 3? They can keep that in any other part, right? Because they are most important than the fundamental rights. Without these two articles, nothing in the constitution makes any sense.
First explain pre-constitution.
Pre-constitutional laws are the laws which are made before the constitution has come into the place, means British laws under which we are governed. Suppose there is a law which is encouraging untouchability, that is against our constitution, right? So whatever the things which are against the constitution won't be passing it. Passing means won't be valid. Those becomes invalid. If the law totally is against the constitution, that will die. But if only part of the law is against the constitution and part of the law is not against the constitution, that part which is not against the constitution will be a law. And that part which is against the constitution will not be a law. Suppose there are 10 clauses are there. Only 3 clauses are not according to the constitution. Rest all the 7 will be there, will be alive. Only these 3 will be dead. Clear? కన్ఫ్యూజ్ చేస్తే కన్ఫ్యూజ్ అవుతారా ఇప్పుడు? అవ్వరు కదా, ఎందుకంటే క్వశ్చన్స్ కన్ఫ్యూజ్ చేయడానికే పెడతాడు వాడు. యూ షుడ్ బి హ్యావింగ్ క్లియర్. ఇందాక త్రీ టైప్స్ ఆఫ్ బిల్స్ వేర్ ద ప్రెసిడెంట్ హ్యాస్ టు గివ్ ద అసెంట్. Not everyone answered. I am not taking no one answer. Not everyone answered, right? Okay. So, okavela if they go for the ordinance, again the same process of the ordinance. Within 6 months of the reconstitution of the Lok Sabha or Parliament session, within 6 months they have to pass it. Ordinance ఎన్ని రోజులు ఎలైవ్లో ఉండొచ్చు? 6 months అక్కడికే అయిపోతుంది అందరి ఆన్సర్, ప్లస్ 6 weeks, రైట్? ఫైన్.
Sir, Article 370 repealed by Article 245. Kashmir demand Article 370. అది దీంతోనే రిపీల్ అయింది 245.
Article 370 is a special clause. They haven't repealed anything. The government can also bring the legislation to repeal the form laws. Okay, that is what. House of the Parliament. Clear? Any doubts on this? Now we have almost done Parliament. We are going for the new topic. If you have any doubts, let me know. Otherwise, we'll go for the new topic.
So one second, subsidiary motion. Subsidiary motion. Subsidiary motion. Substantive.
These two differences you want. Or?
Only subsidiary.
Why a motion will be passed?
For discussing something, a matter of public importance, we need some time.
Hmm.
So motion will be passed then.
What are the different types of motions we have? Hmm.
Subsidiary, substantive,
Hmm.
substitute.
Subsidiary motion is kind of a subsidizing an effect which is already there. If they want to discuss something very important, they will be passing a motions, right? Privilege motion is different. Subsidiary, substantive, and substitute motion. These are the three types of motions. These two are kind of a equal importance, wherein they want to speak about an urgent matter which is going on that day or on that week. They have to take the permission and they have to pass a motion. If they pass these motions, regular course of the parliament will be stopped and this topic would be discussed. Right. Substitute is substituting this both. Right, that is the difference. Okay. Next, we'll try to complete this topic also. How much time we left? 40 minutes. Fine, we can complete. Now, this parliamentary committees, ka questions are there every year in the prelims. Every year. Okay, you can check it. Now, what are these parliamentary committees? Why we need the parliamentary committees? What is the need for the parliamentary committees? Generally, now we have the parliament, right? Why we need the parliamentary committees then? Parliament is doing the work. Why we need special committees then?
They will have some expertise in dealing with some matters.
But in parliamentary committees, only the members will be, right? Parliamentary committees, who is the members? The members of the parliament will be only the members of the parliamentary committee. Then the members of they have the expertise, that means they are already a part of parliament. Clear? For your answer, I am just rebutting it. Your answer is valid. But my question is this. If they want an expertise, that the same members are there. They are not an expert is coming from outside. Because parliamentary committees, members are their own members. Then why we need parliamentary committees? Correct? Question valid? And again, if you know that, then the subject would be very easy. That is the main flaw which is happening, right? They'll go learn everything, but they don't know the exact meaning of it, what they are learning. Because there were two reasons for it. One is time. Second is expertise. In parliamentary committees, there won't be ministers. There will be only members. This is a very important point. Okay, parliamentary committees lo members undaru. Ministers undaru, members undaru. Ardhamainda? This is very important point. Chal, we'll go into the details. And why we need, we already told you that two reasons, right? Fine. Now, parliament is too unwidely a body to deliberate effectively on the issues that came before it. The functions of the parliament varied, complex and voluminous. It is neither adequate nor necessary expertise to make the detailed scrutiny of all the legislature and all the matters. Therefore, assisted by number of committees to discharge its duties. Because parliament in where every other kind of bills will be coming in. Bills in science and technology, bills on space, bills on finance, bills on law, bills on vaccines, bills on international relations, bills on war, bills on nuclear weapons, bills on agriculture, right? Bills on river sharing, bills on water, bills on education. Every other kind of bill is coming to the parliament, or every bill is coming to the parliament, every subject. So there is going to be a huge task for the members or the ministers to understand the things, to form, to discuss, to deliberate all these kind of things, and they have the less time and the work is too big. That's why they want these committees to do specialized works, right? That is a need for the committees. 5. Parliamentary committees means a committee that appointed or elected by the House or nominated by the Speaker or Rajya Sabha. Now, the question is, parliamentary committees can be formed by appointments, by elections, by nominations. Appointments, elections, nominations. Right? Illa adugutar questions. Note it down. In the detail ga meeku book lo undadu, andike note it down. Whichever topic I am telling you to note it down, note it down. Okay? Appointment or elected by the House or nominated by the Speaker or Chairman. Appointed or elected by the House or nominated by Speaker or Chairman. Next, works under the direction of the Speaker or Chairman. Works under the direction of Speaker or Chairman, not President here. Speaker or Chairman. Presents its reports to the Speaker or Chairman again. Works under the control of Speaker and Chairman. President its reports to the Speaker or Chairman. Speaker or Chairman and endukantuna Speaker appoint cheste Speaker ki, Chairman appoint cheste Chairman ki. Right? Has secretariat provided by the Lok Sabha and Rajya Sabha, means the staff, the officers to do the work will be provided by the either Lok Sabha secretariat or Rajya Sabha secretariat. Fine. Now, there is a parliamentary committees. There is a term called consultative committees. Consultative committees are different from the parliamentary committees, but both the objectives are same: to discuss on a topic, to deliberate on a topic, to report to the parliament whatever their discussions or the final report is. But consultative committees consist of the members of the parliament or not committees, as they do not fill the above four conditions. These consultative committees they consist the members of the parliament and are not parliamentary committees, as they do not follow the four conditions. What are the four conditions? The above four conditions. If the above four conditions are there, then that is a parliamentary committee. Other than that, though they have the members of the parliament, that is not a parliamentary committee. Here the major point is appointed or elected or nominated by the Speaker or Chairman. That means consultative committees are not appointed by the Speaker or Chairman. Consultative committees are generally appointed by the Minister. If the Minister is passing a legislation and that is too technical for the Minister, he can appoint the consultative committee to consult with him to explain the Parliament. Fine. Broadly, parliamentary committees are of two kinds, standing and ad hoc. Parliamentary committees are of two types, standing and ad hoc committees. First, we'll Sir, any minister, suppose a legislation is with the finance minister, he can, or a legislation is with the space, science and technology, he can. That is not appointed by the speaker or chairman. They are doing the similar, then that is called consulting. No ministers. Okay, clear? Confusion unte adagandi ippude.
For example, if I am large district minister, I cannot be a part of the parliament committee regarding the land district.
No.
But can I be as a member of parliament?
No. Parliamentary committees లో మినిస్టర్ ఉన్నాడు అంతే, అది ఫ్యాక్ట్, అది ఏదైనా కాదు. క్లియర్? Now standing committees, it is one of the parliament, it is one of the kind of parliamentary committees, right? Standing committees. First is finance committees. Finance committees mein there were 3 finance committees అని చెప్పాను నేను. Right? What are the 3 finance committees? You haven't noted it down. Yesterday we discussed 3 finance committees here. I told you, and I given a shortcut to remember also. So first one already there, public accounts. Second is estimates. Third is public enterprise. Committee on public enterprise. These are the 3. Now we'll discuss one by one. These 3 are very important. First is public accounts committee. Now public accounts committee is formed, set up first in 1921 under the Government of India Act 1919, and since then it is still working, right? 1921 by the Act of Government of India Act 1990. It consists of 22 members, 15 from Lok Sabha and 7 from Rajya Sabha. And this elected by the members, like all these members should be members of the parliament from both the houses, as there are members from the Lok Sabha and members from the Rajya Sabha. And there is no minister, and the term is 1 year. These members have to be elected every year. The term is only 1 year, right? 22, remember the number, 22 members, 15 from Lok Sabha, 7 from Rajya Sabha. Members elected every year. The term of the office is 1 year, and there should be no minister in that committee. The chairman of the committee is appointed amongst its members, means amongst the 22 members, those who are selected for that committee. Till 1966, the chairman is from the ruling party. After 1966, from 1967, the chairman is from opposition party. Okay. The function of the committee is to examine annual audit reports of CAG, Controller Auditor General of India, right? Now public accounts committee, what is their main job? To look into the accounts of annual reports of audit reports of CAG. Now here the question is whether they will be looking into these reports before they submitted or after they submitted. After the CAG submitted or before the CAG submitted? After. When the CAG has a responsibility to submit annual reports to the parliament. Once it is submitted in the placed in the parliament, this committee will take the report and they will examine that report. That is their job. This job is going on from 1921. Clear? Next is estimates committee. This is also very important. The uniqueness of this estimates committee is all the members are from Lok Sabha, right? Okay. It constituted in 1950 on the recommendation of John Mathai, the then finance minister. John Mathai is a finance minister of that time. Originally it had 25 members, but in 1956 the membership has increased to 30. All the members are from Lok Sabha. No Rajya Sabha members in this committee. That's why it is very important committee, because it is unique. The chairman by the speaker amongst its members, but always the chairman is from the ruling party. It is not a condition, but normally the chairman of the estimates committee is from the ruling party. What is their main function? To examine the estimates including in the budget and suggest the economies in the public expenditure, and also described as a continuous economic committee. It is also described as a continuous economic committee. They will normally discuss on the budget estimates. That's why it is called estimates committee. Clear? Limitation: budget estimates only after they have been voted by the parliament and not before. So these recommendations are not binding on the parliament. Okay, that is clear. Like public accounts committee, it is created in 1964. Recommendations of Krishna Menon committee. Remember these recommendations, by whom this committee is, by why this committee is opposed. Krishna Menon committee. Public accounts committee is created in 1964 on the recommendations of Krishna Menon committee. There are 22 members, 15 from Lok Sabha and 7 from Rajya Sabha. The chairman is appointed by the speaker from amongst the members who are drawn from Lok Sabha only. Chairman is from Lok Sabha only. Now we discussed 3 committees, right? Now what are the similarities of 3 committees? It functions three committees are dealing with the finances. Okay, one is about the CAG, one is about the estimates, one is about the public sector undertakings, right? And except estimate committees, all the members are from Lok Sabha. Okay, this public accounts committee and public undertaking committees, there were 22 members, 15 from Lok Sabha, 7 from Rajya Sabha. All the 3 chairmen are elected by the speaker, not by the chairman of the Rajya Sabha. Right? Finance committees ki most of the powers, most is inclined to the Lok Sabha, because finances. Right? Clear. Major members kuda Lok Sabha ne unnaru. Estimates lo 30 and other 2 may 15 out of 22. Clear? These are the differences. Remember that. And another is any recommendations. All the 3 committees' recommendations are not binding on the parliament. Right? Clear? These are the major similarities between all the 3. Fine. Now we will see the functions. To examine the reports and accounts of the public undertaking, to examine the reports of CAG, general and public undertaking, to examine in the context of autonomy and efficiency of the public undertaking. This public undertaking committee ka functions. This is also once asked in the mains. This exactly the same. What is the role of public undertaking committee? Do you think it has changed anything? What is the importance? Right? Why they had at the time they asked means many of the public undertakings, many of the mini ratnas, all these public undertakings are privatized. So that's why they asked this question. What is the role of public undertaking committee and all? So we cannot say this is important, that is important. Whichever comes in the newspaper for last 1 year, there will be implied questions on the topics. Okay, now also there is a good disinvestment ka topic chal raha na. All the public undertakings are on sold. Everything is disinvested. Okay, to exercise such other functions which public accounts committee and estimate committees in relation to the public undertakings are allocated by the speaker from time to time. Its recommendations are advisory and not binding on the ministries. And also see the chronology. Public accounts committee is 1921, estimates committee 1950, and this public undertaking committee is 1964, right? 1964, right? Clear, right? Now we will go for the departmental standing committees. What are these departmental standing committees? Initially there were 17 departmental standing committees. Later in 2004 it has raised to 24. So right now there are 24 departmental standing committees. The main objective of departmental standing committees is to secure more accountability of the executive, that is Council of Ministers, to the Parliament, particularly a financial accountability. They assist the Parliament in debating the budget more effectively. 24 standing committees cover the jurisdictions of all the ministers and departments of the central government. Each standing committee has 31 members. Remember, all the standing committees has 31 members, 21 from Lok Sabha, 10 from Rajya Sabha. Remember that point, very important. The members of the committee are nominated by the preceding officers of the houses. A minister is not eligible. Out of 24 standing committees, 8 for Rajya Sabha. Out of 24 standing committees, 8 for Rajya Sabha and 16 for Lok Sabha. Clear? Standing committees. Why the standing committees? Because every department will be having a standing committees to discuss the topics of that department. Now we have 24 standing committees. Each standing committee has 31 members, 21 from Lok Sabha, 10 from Rajya Sabha. Right? And how many standing committees are there in the Rajya Sabha? 8. How many are there in Lok Sabha? 16. Every point is important. Every point has a potential to ask in a question. Right? They can ask like Rajya Sabha has less number of parliamentary standing committee than in the Lok Sabha, or they vice versa they can ask. So remember these points, don't be confused, by heart it. Only then you can answer the questions. Now next one is committees on inquiry. The first one is committee on petitions. The committee on petitions examines the petitions on the bills and on the matters of general public importance. It also entertains representation from individuals and associations on the matters pertaining to union subjects. Lok Sabha committee consists of 15 members and the Rajya Sabha committee consists of 10 members. Committee on petitions means normally who gives the petitions? Petitions are given by the outsiders to the members of the house to discuss on a particular issue or to solve a particular problem. Ante kada, ipudu manaki edana problem unte we'll go and submit a petition. Right? This committee will be checking what are all the petitions has come, what is the status of that petitions. Okay? Remember, Lok Sabha has 15 member, Rajya Sabha has 10 member. And that means both Rajya Sabha and Lok Sabha has separate committees, separate petition committees. Understand why they have separate petition committees? Someone can go to the Lok Sabha or Rajya Sabha and submit a petition. It is not necessary that same person will go always to both the houses. Right? Clear, right? Now committee on privileges. Committee on privileges. The function of this committee are semi-judicial in nature. It examines the cases of breach of privileges of the houses and its members and recommends appropriate action. The Lok Sabha committee has 15 members and the Rajya Sabha committee has 10 members. This is again a potential question can be asked. This is the only committee which has judicial, semi-judicial in nature. semi-judicial or quasi-judicial in nature, because it has the power to take action or give punishment. Right? Lok Sabha 15 members and Rajya Sabha 10 members. Next, Ethics Committee. Ethics Committee is also important because it constituted first in Rajya Sabha than in Lok Sabha. Rajya Sabha in 1997, Lok Sabha in 2000. Right? It enforces a code of conduct of its members. It examines the cases of misconduct and recommends appropriate action. It is thus engaged in maintaining discipline and decorum of Parliament. Now, does this ethics committee is quasi-judicial in nature or not?